Next, we have Attorney Don Palmer, who is an attorney with Goehring, Rutter, and Boehm, who has worked with us all along throughout the process. Don.
Thank you, Dr. Ondak. As Dr. Ondak indicated, my name is Don Palmer. I'm partners with Patrick Clare. I'm an attorney who does a large amount of real estate work. I have been a member of the team that has been working for quite some time now to explore options available to the district for a possible site for a new high school. As Mr. Pusateri indicated, as Sandy has indicated, it has been a challenging process. The review has been thorough and exhaustive, and the options available appear to be somewhat limited given the particulars of property in this area. Sandy indicated that what appears right now to be the most viable piece of property is property that's owned by Three Rivers Trust. I participated in the negotiations with counsel for Three Rivers Trust to put together an agreement of sale. That agreement of sale is before the board this evening, and what I wanted to do was to take just a few minutes to review some of the main terms of that agreement of sale. The seller obviously would be Three Rivers Trust. The district would be the buyer. The primary objectives of the agreement of sale are, first, that the district needs to acquire the right to enter upon the property to engage in whatever tests and inspections are deemed necessary by the district engineers in order to determine whether the property is suitable for its contemplated use and purpose. We've indicated that this property appears to be the most viable property, but to date, we have been able to look at some title information, we have looked at some record information, we have been able to walk the property, but we've not been able to do the type of analysis that has to be done in order to be able to make a determination as to whether this property is the right property for the district's needs. And so one objective for the agreement was to get the right to enter the property and engage in whatever tests and inspections we want to do. The second objective, and along with that, is to secure the ability for the district to terminate the agreement of sale and to recover its hand money in the event those tests and inspections lead to the conclusion that the property is not suitable for the contemplated use. That was the second goal, and obviously the third goal was to obtain the right to acquire the property if it turns out that that is the right property. In a nutshell, the objectives were for the district to get control of the property so it can thoroughly review the property and analyze the property and make a determination as to whether that piece of property is the right property for the district. As Sandy indicated, the property contains 7 parcels of ground totaling approximately 128.74 acres of ground. It's situate partly in Lee Township, partly in Edgeworth Borough, and partly in Leedsdale Borough. The majority of the property is in Lee Township. The 128-acre total is based on the existing record deeds for the property. We have seen some survey information that suggests the property may be, consist of additional acreage. It may be 130 acres, something like that. That will all be examined as part of the due diligence. One issue that I want to comment to the board on, and you're familiar with this discussion, is that the current owner of the property presently utilizes the property to harvest maple syrup from maple trees on the property. The seller has expressed an interest in continuing to harvest maple syrup, if possible, following the district's purchase of the property. There are provisions in the agreement of sale that indicate the parties will sit down during due diligence and discuss that desire of the seller. A determination simply can't be made right now as to what property the district needs, whether it needs all the property, some of the property, until we get testing information. If it turns out that the district likes the site but doesn't think it needs the entire site, we will sit down with sellers and go over that and try to reach an agreement to buy perhaps less than the whole site. Obviously, that would involve discussion of the consideration for the purchase as well. But the agreement will lock up the site for us, so we don't, our ability under the agreement of sale is to buy the whole site. But we do have the option to engage in discussions if those discussions are needed. The consideration, as Sandy mentioned, is $7,500,000. The agreement provides that within 5 days after the agreement of sale is executed by both the Board of School Directors and the seller, that the district will deposit $100,000 with the title company to be held in escrow as hand money. The balance of the purchase price would be paid by the district at closing, assuming that we get to that point. I think that the key aspects of the agreement of sale are that the district will have the right for a period of 120 days to go onto the property and to conduct any tests and inspections that the district deems advisable. It's at our discretion as to what tests and inspections we decide to do. Those tests and inspections may include surveys, title examination, environmental tests, soil tests, geotechnical tests. There'll be a slew of tests. All of that at our right to go on there so we can thoroughly vet the property and make sure that that property is indeed viable for the use that we intend to use the property for. If during that 120-day period, the district determines that the property is not suitable for its intended use, the district has the right to notify seller that we're terminating the agreement of sale. And upon giving that notice, the title company will relinquish the entire $100,000 hand money back to the school district. So we get a full opportunity to go in and look at the property and determine whether that site actually is a good site. In addition to the due diligence that I talked about, we also have the right to explore getting necessary approvals to put a school on the property, permits, authorizations, approvals from the Department of Education. Anybody who may have a role in this process, we have a period of 210 days, again, starting with when that agreement is approved, to seek out all the land use approvals and permits that we need. Like the due diligence period, if in the first 120 days we're unable to get those permits, we have the right to terminate the agreement of sale. If we terminate the agreement of sale, the district gets its hand money back and the agreement is null and void. If we go beyond the 120 days and up to 210 days, we still have the right to terminate the agreement based on approvals. If we terminate at that point, the agreement provides that the district would get back $65,000 of its hand money. So a little bit less because the property has been off the market at that point for quite some time. Closing under the agreement of sale, if it occurs, would take place 240 days after the agreement of sale is executed, and that obviously assumes that we've not elected to exercise our rights to terminate the agreement. At closing, the hand money deposit would be applied to the purchase price, and at that point in time, the district would be required to pay the remaining balance of the purchase price. Obviously, there are a lot more provisions in the agreement of sale, but those are the main provisions that I wanted to share with you.